There's a very interesting discussion that comes up from time to time with regard to private car parks and parking charge notices, to be precise. And the specific argument is whether or not someone agrees to those terms simply by entering the car park and parking. Now, this was dealt with in quite some detail in the Bevis and Parking Eye case that went to the Supreme Court. Now, the specific argument I'm referring to is if someone as a motorist were to enter the car park with the specific intention of being a trespasser, thus not accepting the terms of the car park, could they still be held liable to the parking charges and the parking charge notice and so on? So I thought I would look at one or two paragraphs from the Bevis judgment, which does deal with this in some detail, although the case differs slightly in that Bevis did accept that he was contracting with the car park. He was just disputing whether or not the parking charge was reasonable or whether it amounted to a penalty, and that's what that particular judgment was looking at. But nonetheless, the court did touch on these couple of points, so I thought this would be useful reference for this very argument as to whether someone could be a trespasser in their claim to disavow any knowledge or agreement to a contract with the parking company and so on. So paragraphs 107 and 8 are interesting in that regard because it talks about the situation where the motorist denies any contractual liability with the parking management company. And specifically it says he would have been liable to the landowner in tort for trespass, but that liability would be limited to the occupation value of that parking space. However, to that extent, there would be an imbalance in the parties' rights, and therefore it's necessary to consider whether or not this is in good faith or in bad faith. But in this situation, it didn't arise contrary to the requirement of good faith, because Parking Eye, the management company, and the landlord for whom the parking management company were operating, was providing this service for a legitimate interest in imposing liability on the motorist in excess of the damages that would ordinarily be recoverable at common law, in other words, the tort of trespass. And Parking Eye, being the management company, had an interest in inducing him, the motorist, to observe the time limit for parking in order to enable other customers, other motorists, to use the car park and retail outlets appropriately. And so moving on to paragraph 108, the court phrases this question as follows. Could Parking Eye, dealing fairly and equitably with the consumer, reasonably assume that the consumer would have agreed to such a term in individual contract negotiations? Now, it goes on to say that this concept of negotiating an agreement for a car park is somewhat artificial. But then the court goes on to say that the question is not whether Bevis himself would have agreed to the term imposing this £85 charge in a negotiation, but, and this is the main point, whether a reasonable motorist in his position would have done so. And in our view, in the court's view, a reasonable motorist would have agreed. Now, in this particular case, which is likely to be the case for most car parks, although of course every single case turns on its own facts and how clear the signs are and so on and so forth, but in this particular case, the court said that these terms as part of the contract were presented to motorists on a take-it-or-leave-it basis, and that in this case they could not have been briefer, simpler, or more prominently proclaimed. In other words, they couldn't have been clearer to all motorists entering the car park that these were terms that if you park here and you overstay, then this is what you're going to pay as a parking charge notice. And the court said in this case, motorists could hardly avoid reading the notice and they were under no pressure to accept his terms. And going on even further into paragraph 109, the court said objectively they had every reason to do so. They were being allowed this free parking and in return they accepted the risk of being charged this overstay £85 charge. Now, taking this into a normal situation with any normal car park, obviously it would depend on how clear the signs are. There have been cases since the Bevis case that have successfully argued that the signs were not clear enough, not prominent enough and not near enough to the spaces being parked, and therefore it was unfair to hold this motorist to those terms. But assuming the case where a car park has reasonably clear terms at the entrance to the car park and dotted around the car park so that they are visible from wherever you are parking and the terms are clear, the argument that someone might say, I'm trespassing on this car park, I'm not accepting your terms, is not really the question. The question for the court is, would a reasonable motorist seeing those signs, entering the car park, parking on that car park, agree to these terms, would they agree to the contract formation by conduct by parking on the car park? This case makes it perfectly clear that a reasonable motorist would accept those terms if they are sufficiently clear. Therefore, it follows that the argument that someone is intending to be a trespasser, thus disavowing any contractual relations with the parking management company whatsoever, is, in my view, not a workable argument. So, in my view, it is not possible for someone to go onto a car park, proclaim that they are a trespasser, thus not accepting the terms of the car park, the terms of the contract, and thus not being held to those terms and any parking charge notice that follows. So I hope you found this a useful discussion. Please like the video and subscribe, and as always, thank you for watching.